Hello friends, in the series on the income tax cases, today we will discuss an issue in respect of taxability of subscription fees received by a resident of Singapore for the use of application developed by the Assessee, and that application is being used by various customers in India. This issue has been taken by Honorable Delhi High Court in the case of Commissioner of Income Tax International Taxation versus Salesforce.com Singapore Pte Limited. This case has been reported in 465 ITR at page number 257, and the date of the judgment is 14th February 2024. In the present case, the assessee is a tax resident of Singapore, and the assessee has developed a business application regarding customer relationship management services application, and this application was in the form of enterprise business application enabling customers and subscribers to record, store and act upon business data and formulate business strategies, and enables the various businesses to manage customer accounts, track sales and sales positions, etc. During the assessment proceedings, the assessing officer showcased the assessee that the subscription fees received by the assessee for the use of this business application why should not be treated it as royalty under section 9 subsection 1 clause 6. The assessee pleaded before the assessing officer that the assessee has not transferred any copyright rights, only the copyrighted articles have been transferred, and this does not come into the definition of royalty. The assessee also pleaded that the question of royalty comes only when there is a transfer of any right in respect of any patent, invention, model, design or secret formula. But the assessing officer assessed the subscription fees in the hands of the assessee. The assessee took this matter to the further appeals. The tribunal has given the relief to the assessee. So the revenue moved to the High Court. When High Court heard this matter, which was already in favor of the assessee, the High Court said that in the present case, copyright in application was never transferred to the customers of the assessee, and therefore the fees or the subscription which was received by the assessee from the various customers in India for the use of the application was not assessable under section 9 of the Income Tax Act. Delhi High Court said that in the present case, Article 12, Sub-Article 4, Clause B of the Double Taxation Avoidance Agreement between India and Singapore is not applicable because the assessee has not provided any technical knowledge, experience, skill or know-how. Delhi High Court said that the customer has been accorded only access to the application, and he was taking the advantage of analytical attributes of software which does not come into the definition of the royalty. Delhi High Court further said that in the present case, there is also no question of providing technical services because the services rendered ought to have satisfied the make available test, and such services should enable the person acquiring the services to apply technology contained therein. So in either case, whether as royalty or fees for technical services, the assessee is not taxable under section 9 subsection 1 clause 6 or section 9 subsection 1 clause 7. Friends, this case is very important because in number of the cases now it is seen that the various non-residents are making different type of business applications or mobile applications, and they are being used by the customers of India and they are paying the subscription fees. So the question may arise whether they are taxable as royalty or fees for technical services, though. So this case is very helpful in all those cases. Thank you, friends.